Today on Don't Talk TV, I'd like to take a quick look at a very welcome decision from the Ontario Court of Appeal with respect to the powers of border guards or CBSA agents to take your cell phone and search it. Hello, my name's Nicholas Wansbutter. I'm a lawyer in Stratford, Ontario, Canada, and welcome to Don't Talk TV. So just a couple of weeks ago, the Ontario Court of Appeal released a decision, His Majesty the King and Pike. As always, we're going to have a link to that case in the show description below, so you can look at the whole decision. It's about 120 pages. I'll just be doing a quick summary of the case, but I wanted to talk about it because I think it's a very important and a very welcome decision because it's curtailing some of the, in my view, out-of-control powers that CBSA agents have had. I mean, up till now, the Customs Act, the way it was worded, has essentially made the border a charter-free zone where you just really have no rights. I know even as a lawyer, that's how I've felt going to the border. I feel like I have no rights approaching the border. They can just take my cell phone, look into my closest secrets if I had my cell phone with me or if I had all my apps installed. But the Ontario Court of Appeal has I think this is a very good decision, have said, no, this is clearly a breach of the Charter and the government needs to rewrite the law. So before we get into the decision, let's look at the section of the Customs Act in question. So I have the Justice Law's website open. We've got the Customs Act open here. And if we go to section 99, specifically 99 sub 1, this is the section question here. Any officer may, at any time up to the time of release, so any time that you're at the border dealing with a CBSA officer, they may examine any goods that have been imported and open or cause to be opened any package or container of imported goods and take samples of imported goods in reasonable amounts. Imported goods has been taken to mean anything in your possession. So if you have a cell phone in your pocket, that's an imported good that they can open or they can cause you to open it, meaning you have to give them, up until this decision of Pike, you have to give them your passcode, unlock it, and they get to take samples. Now that section has been in force since at least 2017, and I'm sure there was variants of that available earlier that were very much the same. This is something that's been going on unchecked for years, and that's a huge problem. So I'm glad that it's been appealed and that the Court of Appeal has rendered this decision. Now, it wasn't under the most auspicious of circumstances, as we'll see. Let's go straight into the case. So here we have the decision from the Ontario Court of Appeal, His Majesty the King and Pike, 2024 ONCA 608. And Chief Justice Tulloch gives a very helpful overview that saves me from having to go through all 120 pages, although again, the link will be below, so you can have a look at that if you want, but this overview gives a perfect summary of the case. So he starts off by saying, millions of Canadians travel internationally each year with their personal computers, tablets, and smartphones. The contents of these devices attract some of the strongest privacy interests known to law because they are a window into their users' lifestyles, beliefs, interests, desires, relationships, finances, health, and much more. But one of Canada's border laws, namely Section 99 sub 1 sub A of the Customs Act, authorizes border officers to search those devices without any reasonable basis. Two travelers, Jeremy Pike and David Scott, whose devices were searched under this law, and who were consequentially charged with possessing and importing child pornography, challenged the constitutionality of the law. So that's where I said it's not under the most auspicious of circumstances. I mean, quite frankly, as far as I'm concerned, these two men are scum. I mean, child pornography. But the law is the law. The law has to apply to everyone. So I'm glad that the Court of Appeal still made the right decision, notwithstanding the absolute vileness of what these men had on their cell phones. So the principal issue in these appeals is whether sections 99 sub 1 sub A of the Customs Act are constitutional. And here we have it right here. The answer is clear, it is not. Section 8 of the Charter of Rights and Freedoms guarantees everyone the right to be secure against unreasonable searches. I agree with the trial judge that Section 99 sub 1 sub A of the Customs Act offends this basic guarantee because it authorizes border officers to search some of the most private information imaginable on the lowest possible standard to justify a search, namely that in the border officers' own minds, they were sincerely trying to find evidence of border law violations. In other words, there is no standard. It's completely arbitrary and random. They can search who they want. So it says, while sincerity is a good start, it's not enough. Charter requires more because Canada's border control interests temper but do not eliminate or gut its protections. A reasonable search in this context requires a reasonable suspicion, meaning objective facts that establish a reasonable possibility that officers will find evidence of border law violations on the device. So in my view, that decision, those words, that's right on the money. That's exactly what the Charter is about. This is why we have the Charter, is to protect citizens against laws like this. It's a complete overreach, and again, I think it's a very welcome decision. Now, interestingly, the court did find that although this section of the law is unconstitutional, that did not warrant an acquittal to these men. So in the Charter, Section 24.1 and 24 sub 2 are the sections that lay out what remedies are available. So in a case like this, where they said the officers were acting in good faith, this law has been around for years, so as far as they're concerned, it's law. They're not lawyers, they're doing what they've always been doing. So that good faith, now I think the good faith can be overused sometimes, but in this case, it seems to be fairly legitimate that the officers would believe that this law that's been in effect for more than 5 years, without having been overturned in that time period, they would use the law as it's written. So in those particular circumstances, given the good faith of the officers and given the utterly heinous nature of what they discovered and what these men were charged with, they don't get acquitted. They're still getting convicted, but from this point forward, that law is of no force and effect, and the government has to change it. So if the CBSA were to use those powers from this point forward, now that this decision's out there, they would not be able to rely on that good faith. Because they wouldn't have good faith, because they're expected to require, or they're expected to know decisions like this. So moving forward, I believe that evidence absolutely would be excluded. And I think this approach makes sense, because otherwise you'd have to be going back 5 years, maybe even decades, of people trying to overturn cases. If they said this is retroactive, the CBSA ought to have known. They shouldn't have used this law even though it was on the books. So I think in this circumstance it makes sense to not grant these men an acquittal, but to make it clear from this point forward, you can't do this anymore. So in my view, it's a very good decision. I'm glad to see it, and should give Canadian citizens a little bit more peace of mind when traveling, that you do have rights at the border, and you do have the right to privacy. So this video, of course, is not legal advice. If you need legal advice, you should call lawyers so you can get specific advice tailored to your situation. If you want me to be that lawyer, my contact information is listed below. We're always open to suggestions of topics you'd like to see us cover, so please send an email to the address listed below or leave a comment in the comment section. And if you found this video at all interesting, helpful, or informative, please consider liking, sharing, subscribing, and following us on social media.